What's up, friends? Glad you're joining me on the Challenging Conversations show, brought to you by the Edify Podcast Network. Challenging Conversations is a podcast intended to empower Christians to be bold and not afraid to jump into controversial topics with anyone on any topic, anytime. Now, recently, the Supreme Court, in two separate decisions on June 29th of 2023, they held that college admission policies at Harvard College, including the University of North Carolina, they stated that they were using these certain admissions according to race as a factor that was actually deemed unconstitutional and therefore not lawful under the Equal Protection Clause of the 14th Amendment. So what we are going to be discussing on today's podcast here on Challenging Conversations is exactly that. I understand that there are many people listening or watching this podcast will say the Supreme Court got it right. And of course, they're going to be well-meaning Christian people who would say, no, they got it wrong. And let me just say this, as someone who is biracial, who has benefited from some programs that were offered in Arizona at the time when I was going to junior college to get a transfer scholarship, there were some opportunities coming from a lower class. We did not have the funds, okay? We did not have the programs from elementary on up that were providing me access to, some of these degrees, okay? But I had to work hard, and there were some opportunities here and there, not much, but enough to kind of, help reduce some of the cost in some areas. But I had to work hard. I had to get a certain GPA. I had to write certain types of papers. I had to have certain level of merit and character. I had to have some things I had to do that were contributing, not just to society, but also to my future path in education and in my career, etc. I mean, there are things that we had to put together with the help of my counselor. So when it comes to affirmative action, the whole purpose of this is to bring diversity within a setting, within a culture. And the thing fundamentally we have to understand before we dive in to really look at these things, I'm going to give you 5 things to respond when it comes to what the Supreme Court has done and looking at it, okay, objectively with a biblical lens of knowing that we are all made in the image of God and we are all equal. That does not mean equal outcome. That means that we have equal opportunity. But you cannot expect or demand that your riches and success is a responsibility of a particular institution or policy, okay? And so we're going to be wrestling with justice and fairness. And sometimes that could be arbitrary. And sometimes it could be subjected to an individual. But we have to understand that there are disparities that are among certain ethnic groups, certain classes of individuals who are not given opportunity to prove themselves. And that, as a Christian, I want to fight for. And I hope and pray that you will as well. So if you hear this podcast and you're really moved by it and you want to respond to me and share your story or maybe questions you have, man, I'd love to hear from you. So before I dive right in, I want you guys to be aware you can go to standstrongministries.org and you can click on the contact button there and you can email directly to our ministry at info@standstrongministries.org. We'd love to hear from you. Now, when you go back to this case, though, of the Supreme Court looking at affirmative action and how schools, particularly Harvard and North Carolina, were using affirmative action by, in essence, overlooking or discarding certain people for a particular group of other people, predominantly Black and Hispanic. They were not looking at it in merit. And there was a lot of things that were going contrary, again, to the Equal Protection Clause of the 14th Amendment. And we'll talk about that in a minute. But when I was looking at this case, there's one voice out there that is tremendous. He's an expert in the Constitution. His name is Dr. Robert P. George, and he represents he's a McCormick professor of jurisprudence at Princeton University. And he asked this fundamental question, and this is where I want to begin the discussion, okay? So let's just, no matter what political party you may be a part of, and of course my show is to an audience of Christian thinkers, Christian believers. So he asked this question. He says, for the sake of increasing racial and ethnic diversity, so let's pause. Remember, affirmative action at the heart of it is what that's what it's supposed to accomplish. Okay, so affirmative action is defined by the Holton case in 2014 as policies in which an institution or organization actively engages in efforts to improve opportunities, catch this, for historically excluded groups in American society. So remember, we're looking at improvement of excluded groups. Okay, so keep that in mind. In the Holton case, it also says from 2014 to also enhance educational experience through diversifying perspectives as well as reallocating resources from students in the majority to underrepresented minority students. That was also in another Supreme Court case of 2015. So in this last ruling that just took place, and basically saying that affirmative action at the heart of it is the practice itself has become unconstitutional. This is why Robert P. George has asked this question for the sake of increasing that racial and ethnic diversity. Okay, may state colleges and universities, or colleges and universities who benefit from state or federal governmental funding or qualify as public accommodations under civil rights laws, take race or ethnicity as such into consideration in making admissions and by implication hiring decisions? So is it right for institutions, if they're trying to diversify, to solely look at someone's color of their skin? And through that, or by that, or according to that, use that as the measure to admit, to qualify, to hire someone? Is that, again, properly how affirmative action should be handled? Okay, so that's at the heart of what is happening here. Now, again, as mentioned, Holton was one of the cases that was brought to the Supreme Court. There have been other previous cases that are brought to SCOTUS about equality by factoring in a holistic evaluation, including race. And this is where it becomes arbitrary. This is where now affirmative action, though I've laid out that there are policies to help organizations to be active in improving diversification. Because what we have seen, and I'm totally a proponent of this, is to have groups of diverse people, not just of color of skin, but of opinion. Okay? And in my book, when I talk about racism, how to end it and pursue racial reconciliation, one of the things that I encourage families to do is make sure that even your kids have diverse friends. Okay? Now, be careful what that looks like, but let's first and foremost start with people who represent different cultures. There's beauty in that. That's the culture I lived in growing up in Tucson, Arizona, where I had Hispanic community and Middle Western, Caucasian culture. Okay, and there's definitely the way that we did birthdays and celebrated certain things, and the foods that we ate were different on both sides versus my mom's side versus my dad's side. But there's beauty and diversity. Okay, so I'm very sensitive to this, and it has shaped the person that I am today. So the point here that we're talking about is that the court, up to this point, when they're evaluating this case as brought before them against Harvard and also against the school at UNC, was they were asking this fundamental question: is were colleges, really creating diverse cultures? Were they really creating better cultures on campuses based on affirmative action, based on using race in admissions? Because up to this point now, the courts have been not approving, but they've been citing, or they have been lenient, believing that we all believe in diverse cultures and that it enhances people's experience and education, etc. That's a good thing. So they were being lenient, and they were hoping, right, and basically putting faith in these institutions that they were doing that accordingly. But that has not been the case. So in this recent case brought by the Students for Fair Admissions Incorporated, which is made up of 20,000 students and parents, they sued the president and fellows at Harvard College, and they petitioned this for fairness, quote, to support and participate in litigation that will restore the original principles of our nation's civil rights movement. So let's pause and remember, Affirmative action is a process to try to diversify, to increase the culture, to enhance it, to improve it in an individual's experience, giving them opportunity, okay? But at what point or at what cost does that affirmative action then start now interfering or infringing in other people's rights? So the nation's civil rights is to protect every man and every woman, okay? So they go on to say that a student's race and ethnicity should not be factors that either harm or help that student to gain admission to a competitive university. So there's the distinction. This is not just about choosing someone based on the color of their skin and therefore excluding or disqualifying someone because they lack that color. This is about merit. This is about getting accepted into a competitive university, meaning you're not just coming because you're a certain gender or color. You're coming and you qualify. And again, most of these places have a waiting list, right? Every university at some point has limited space. So they can only bring in a certain amount, some more than others, obviously, depending on the size and their budget. So in a 6-3 decision, you have Roberts, Thomas, Alito, Kavanaugh, Gorsuch, and Barrett. They all sided by stating that affirmative action has become unconstitutional, that it does defy the Equal Protection Clause of the 14th Amendment. And of course, Justices Ketanji Brown, Jackson, Sonia Sotomayor, and Lena Kagan, they dissented. Now, what we have to understand here, and this is so important when I was looking at this stuff, my friends, what you have is an unequal, or to be more specific, you have a regulated system that at this point, by using affirmative action and abusing it, basically, it prevents certain class of people from getting in due to them not meeting certain criteria. And the question now is, what has that criteria become? And says whom? And this is abuse now of civil rights. This is abuse of trying to diversify and bring forth, some order to, these climates or these cultures, considering it being a university or a business. So the question is, again, is the criteria to achieve a certain level or number or percentage of blacks, Hispanics, or whatever the case may be in a certain culture? And at some point, when do you achieve that certain status? And then when does affirmative action become less of a program or something that's been regulated to ensure that? And once you've ensured that, then is it downgraded? Is it no longer applied? So these are questions that no one's been really asking and challenging, and finally it's come to the Supreme Court, and they're saying the practices of this regulated system now of abusing affirmative action has now become so arbitrary that it's actually undermining more people than it's actually improving. Now, that's why Chief Justice John Roberts, who wrote the majority opinion, declared, quote, a benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination. In other words, Chief Roberts says, the student must be treated based on his or her experiences as an individual, not on the basis of race. That is the heart of what we see, you guys, in the Bible. That's reflected in the Judeo-Christian ethic of the Constitution. Okay? We do not discriminate towards anyone based on their race. Again, I like to use the word ethnicity or the color of their skin, because we're one human race. We're all made in the image of God. Chief Justice Roberts says many universities have for too long done just the opposite, which I was just saying earlier. And I do agree with that. And in doing so, they have concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice. Because, he goes on to say, Harvard's and UNC's admissions programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. Those admission programs cannot be reconciled with the guarantees of the Equal Protection Clause, end quote. And one of the things, if you look at what we see according to, let me pull it up right here, the Title VI, because this is what a lot of people look at. And this is important for us to understand based on not just the opinion that came down from the 6 majority justices in deeming the affirmative action being unconstitutional. Notice Title VI, which was enacted as part of the landmark of Civil Rights Act of 1964, prohibits discrimination on the basis of race, color, and national origin in programs and activities receiving federal financial assistance. Okay, so obviously, and this is the point that even Thomas Clarence brought about. You know, if you were looking at the discrimination today versus the discrimination in the 60s, what difference is in 21st century to the 1960s? Because now if you're discriminating predominantly in UNC, particularly in Harvard, where Jews and also Asians, isn't that the same of the discrimination that blacks were facing in the 1960s? Now, President John F. Kennedy said this in 1963. He said, simple justice requires that public funds to which all taxpayers of all races, meaning colors and national origins, contribute, not to be spent in any fashion which encourages, entrenches, subsidizes, or results in racial, color, or national origin discrimination. So the Title VI goes on to say, if a recipient of federal assistance is found to have discriminated and involuntary compliance cannot be achieved, the federal agency providing the assistance should either initiate fund termination proceedings or refer the matter to the Department of Justice for appropriate legal action. Aggrieved individuals may file administrative complaints with a federal agency that provides funds to a recipient, or the individuals may file suit for appropriate relief in federal court. So Title VI, it prohibits intentional discrimination. So this is what we have to look at, my friends. We have to see what has taken place, what has transpired up to this point, which leads me to the first reason why I believe what the Supreme Court had just done with affirmative action was right. Now, that does not mean that all of a sudden we just throw up our hands and forget about all the disparities that are taking place predominantly among minorities. Because I was such a kid growing up where we did not have direct access to a lot of these programs that gave opportunity because we didn't have the money. So yes, we need to make sure that just because affirmative action was struck down on the high court level doesn't mean problem solved. No, in one sense we're saying is, look it, we need to stop this because, and this is what we need to understand. Number one, what it does is this has become now reverse discrimination. Reverse discrimination. So equal protection under the law, favoring certain people over others, is a direct violation of the U.S. Constitution. So what we have now are multiple cases of affirmative action being used, and in the process, it has the reversed effect, meaning it undermines what affirmative action is all about. Now, you're going to have some groups that are going to advance one particular group, and while they do that, they're undermining another particular group. That's partiality. That is wrong. If it happens to blacks, that is wrong. If it happens to whites, that is wrong. If it happens to anyone, that is wrong. Okay? Reverse discrimination is wrong. What we have to look at through this ruling, and as Christians, we have to understand the difference between discrimination and identification. See, what happened was we are just now seeing, oh, they're excluding, discriminating, therefore it's racist, a particular group. No, what we have to see, and that may be the case in some areas, and it clearly was what was happening at Harvard at some point, but I wouldn't say that they're all racists, and we have to be careful. We have to make sure that when we're seeing cases of discrimination and then cases of identification, meaning we have to identify the individual, their merit, their character. Now, the problem with Harvard in the past, particularly in the 1920s and 1930s, was they were excluding Jews from the university. So this has been something that's been happening for over a century at Harvard, one of the greatest, most recognizable schools. And so when you actually look at Harvard, the history of Harvard admissions, look at this. It says, for much of its existence, Harvard admitted students who passed a required exam. In the early 1920s, however, Harvard's leaders became alarmed by the growing number of Jewish students who were getting in. Although Harvard preferred to state frankly that it was directly excluding all Jews beyond a certain percentage, it recognized that an explicit quota would cause at once some protest. So what did Harvard do? They created a holistic admissions system to, quote unquote, reduce the number of Jews. Okay, this is a document on the Supreme Court. Okay, Harvard placed, quote unquote, greater emphasis on character, fitness, and other subjective criteria by making its admissions priorities less obvious. Harvard believed it could hide its true motives. Harvard could say that race was part of the record, but not the whole record. So no student would ever be kept out on grounds of race. Now, a half century later, Harvard submitted an amicus brief in Bake, touting its program as a blueprint for how to use race. It's known as the Harvard Plan. Harvard said its admissions process treats each applicant as an individual. Okay? And the Harvard Plan was inherently capable of gross abuse and had, in fact, been deliberately manipulated for the specific purpose of perpetuating religious and ethnic discrimination in colleges and also in admissions. So again, that, my friends, right there, that is reverse discrimination. And that's what the Supreme Court was saying. This is wrong. We cannot continue to encourage this. Well, now let's look at the second thing, the violation of Equal Protection Clause. And this is why I believe the Supreme Court got it right, was the violation of Equal Protection Clause. And this is something that more of us need to be talking about. Matter of fact, if you go back to what Justice Thomas posed in this direct question, he says, if this case had been brought against a school in 1960 that was discriminating against black students on the basis that segregation yielded educational benefits, would we have deferred to that judgment? So what kind of judgment would that be if you're actually seeing discrimination take place? You see, we as Christians, we believe in the fundamental tenets of the United States Constitution, that all human beings are equal, irrespective of a person's beliefs, their religion, their ethnicity, their social status. We believe that every human being has a fundamental right to be given an opportunity. Notice, not an outcome, but given an opportunity to prove themselves on their merit, on their character. So that's where this violation of Equal Protection Clause has happened to multiple people. Okay, they don't care about their work ethic. They don't care about their character. They don't care about what they have done to prove themselves and what quality they can bring, and also provide a level of diversity, which is that's one of the reasons why you have affirmative action. They don't care about how they can contribute to the school or to that workplace environment for that corporation for future achievements that will pave the way for future generations. So when you look at the 14th Amendment, it guarantees that no state shall deny any person within its jurisdiction the equal protection of the laws. That's what the Constitution says, my friends. It recognizes these certain fundamental rights that these universities were undermining. So they were not applying civil rights. They were not applying that to all individuals. And again, regardless of someone's background or their characteristics, these rights include freedom of speech, assembly, religion, and the right to due process. So this is why Harvard and UNC, they were sued. And this is why they overturned the laws of affirmative action, because of the abuse of it, my friends, the violation of Equal Protection Clause for all people. That's what the Constitution protects. It protects these rights for everyone, irrespective, again, of their race, their gender, or any other personal attributes that they may have. So that is something we have to talk about, I believe, more. I don't think it's just solved completely by the Supreme Court. I think we need to be having these conversations. That leads me to my third thing, unequal opportunity in education. So let's get a little bit more specific now when we're talking about this unequal opportunity now in education. Because again, if you are not affording equal opportunity for everyone, then guess what? They're not going to have an opportunity to be more successful in the past, or from the past to the future. It's like Nick Haley, the former UN ambassador to the United Nations, says. She says, up to this point, what affirmative action has become is picking winners and losers based on race, which is fundamentally wrong. Now, again, you have some programs that are looking for diversity, looking at merit, looking at qualifications. There's some programs that can help scholarship people from a lower class to give them access to certain teachers and programs in institutions that, through charter school or private school, that can benefit that person. Otherwise, if it was left to them and their own devices, they wouldn't be able to afford it. And if they work hard and they can achieve just as somebody who has the money and access to it, and they can even achieve, to their level or even greater, that is a good thing. So it's not about picking winners and losers. It's about selecting people who qualify for whatever program that they have enrolled in or that they've applied to. It's like Heritage said, the reason this is so troublesome is that college admissions are a zero-sum game. There are only so many spots. So a plus factor for one applicant is necessarily a minus factor for someone else. And Harvard and UNC, it seems, impose a significant minus to particularly Asians. So see, you can't say, well, we're providing rights for one group by what? Diminishing or discriminating another group. That is wrong. So when you're talking about these three first things that I've been mentioning so far, reverse discrimination, violation of equal protection clause, and looking at unequal opportunities that are happening among schools, and you now consider this attack against certain groups, this is where you have equal outcome. And that racial equity is directly contrary to the Constitution, and that's what the Supreme Court ruled on. The great American economist and recipient of the Nobel Prize of Economics, I'm sure you guys probably have heard of him, Milton Friedman, he said, quote, a society that puts equality before freedom will get neither. A society that puts freedom before equality will get a high degree of both. And that, I believe, is what the Supreme Court was trying to protect. A society that puts freedom before equality will get a high degree of both. So when you put freedom in front by protecting the equal rights of all human beings, you will get more equality moving forward. And that's what I'm hoping as a result of this decision will take place. And I pray that you will join me in praying that same thing. Now, the former is true of socialism. Although the fight for equal outcomes may appear just, the strategy to achieve this seriously flawed goal is what is actually damaging the country. And over time, that's what we were seeing with affirmative action. It was intended to do good by balancing and providing opportunity with people who are less fortunate. But over time, again, it becomes arbitrary. And again, remember, the courts were hoping and having faith in the systems of these colleges and universities and other corporations that they were actually using affirmative action for the good of diversity rather than discrimination. And we're seeing more discrimination take place as a result of it. Now, one of the problems is that equality of outcome necessitates a guaranteed level of outcome. Foisting equality of outcome over opportunity, actually, what does it do? It strips people of their equal rights. It then starts creating policies and regulations that serve to restrict freedoms of Americans. So again, it's not just discriminating. It's actually restricting someone free access to something, given that opportunity. They have the opportunity, and I'm not saying they should get the job or not, but when you don't even consider them remotely because you're just only considering, and we're going to only give it to a certain group of people, that's discrimination. This is thinly veiled socialism. And that's what the Supreme Court was protecting against, is socialism, which leads to number 4, lack of individual merit. Now, what do I mean by the lack of individual merit? Well, I've been mentioning it throughout this whole podcast, but I want to specifically point it out. This is about undermining the merit of admissions. This is about undermining hiring process. Okay, so when we consider how someone is interviewed, whether it's for a school or for a job, you want to see it based on merit. You want to see the process is not partial, okay, that they can actually overlook, okay, certain things to be a little bit more objective, okay, to be a little bit more wide-eyed open, if you will. So undermining the merit of admissions or hiring process that can overlook the most talented and qualified people is dangerous, because the result of this, my friends, is mediocrity at best. Because what the result is then is, if you are not looking at merit and you're only looking at, well, we need more Hispanics, and these Hispanic people don't meet the criteria. Remember, I asked the question before, what is the criteria? Well, if the criteria is just like, well, we need more diversity, and so even though we have these other candidates who qualify far much better and could bring in more money for the company or the school, they'll do really good for us, which can bring in more money, which then we can probably fund more programs to help people in the inner cities. Instead of looking at it like that, they hire people who are less qualified. They hire people who are not properly suited. They're just hiring them based on a quota. And my friends, that does not end well. When you start applying those same standards to the military, to law enforcement, to doctors, okay, that does not work out in the end. So going back to Heritage, this is what they reported. They gave an example at Harvard that an Asian applicant with academics in the top 10% has a 12.7 chance of getting in. But with the same grades and test scores, a black student has a 56.1% chance. In fact, race is determinative for at least 45% of black and Hispanic applicants to Harvard. The reason this is so troublesome, says Heritage, is that college admissions, again, are a zero-sum game. So this is what we're dealing with, my friends. You know, again, if you have an Asian and black and Hispanic, I can't tell you who should get in if they all qualify, okay? But that's the point. You would hope that if that's the type of tough decisions that these colleges and universities are making, then that hopefully they'd make the right one objectively. But the reality is, this is what we're seeing, and this leads me to my fifth and final point: the underrepresented. The underrepresented. What do I mean by that? Well, here we have to ask ourselves, what are we intending to gain from the underrepresented? Let me put it this way: what are we losing when we don't care to cater for those who are actually underrepresented? Because if we're trying to help elevate an underrepresented class of people to become represented, we want to make sure that as we're balancing that carefully and objectively and impartially, that we're not now creating an entirely new class of the underrepresented. See, it's not about what the university can offer entirely, but what the students can actually achieve. And that goes back to, again, if you have an Asian or Hispanic or black or white person, whatever the case may be, it's what that student can achieve. It's what they can bring to the game entirely. If there needs to be a little bit more diversity, and it can go either way, and you're like, you know what, I think we just do better if we can have more representative of Indians here or Asians, then that school makes that decision impartially, okay? In terms of elevating the education. Because remember, that's what the institution's there for. Let's say if it's a research program. And going back to the Egypt analogy, if Egyptians were tired of seeing the predominant face of the discoveries of their artifacts, of digging up their history, were British archaeologists, okay? And the Egyptians wanted to make a change in that. They wanted to start being represented, of discovering the history of their own people. That's what they have to do, is they have to start building those kind of programs to compete to the level of the British universities. And over time, that's what we're seeing, okay? But they worked at it so they can have their own representation without discriminating against other types of people who can have access to these artifacts and to start digging and do their archaeological discoveries through their different various foundations, okay? And that's what we're saying when it comes to underrepresented, is that you push yourself to excel and not just think that it's solely the responsibility of the government to give you those opportunities, I should say. You should be given those equal opportunities because you were born in America. So what the students plan to do is not up to this institution. But if they see that drive, that this person wants to graduate, and they want to better enhance the common good of society, okay, and they're believing that this institution can help me do that, and it's a partnership, that's what it's all about, instead of discriminating people in the process. Because here's the last thing I want to say about when you look at the totality, my friends, of universities today, and this is still a big problem. And again, the Supreme Court can only solve certain things and uphold to the Constitution. And I believe overall they've done that. But the work isn't finished, because studies show that over 70% of enrolled students at the most competitive universities in the U.S., guess what? They're made up of families that are 25% of the most wealth in the country. So there's no question that there are a lot of young people in America today who don't have money. That was the family I came from. So, but if we're going to make a change, we do need to provide programs and have charitable arms. I've been a recipient of angel donors who helped pay my way so I can get private education. I don't know who those people were, but there was programs that we enrolled in, and by God's grace, we had that opportunity so I can get some better education, okay, than just being stuck into a system and you just graded on a curve, right? And there was no special care, especially for someone like me who had a learning disability. So there's no doubt, you guys, as I close this discussion, again, I don't think that we solved everything, but at least those 5 things can give you an understanding of how to look at the ruling of the Supreme Court. And let me just remind you, there are disparities out there. There are people who are discriminating against certain ethnic or racial groups or certain social classes, and that is wrong. The Bible clearly says in Acts chapter 10, verse 34, this is what Peter the Apostle said, that God shows no partiality. But in every nation, anyone who fears him and does what is right is acceptable to him. I pray that this isn't just about showing favoritism. This isn't just about reducing discrimination. This is about people putting their faith and trust in God, who shows no partiality. The Bible also reminds us in Acts chapter 17 that God made from one man every nation of mankind, okay, to live on all the face of the earth. And he's determined their allotted periods and their steps. So God is actively involved in our lives. So we're not looking to big government to solve all of our problems. We're looking to a big God who loves us and shows no partiality. And finally, Romans 10, verse 12. For there's no distinction between Jew and Greek. For the same Lord is Lord of all, bestowing his riches on all who call on him. And I pray that in the process of this, that people will call upon the name of the Lord. And you, if you have experienced the grace and forgiveness of Jesus Christ, that you would use the resources and the talents and the gifts and the faith that you have to go out there and reach people to reduce these disparities and this discrimination. So overall, my friends, we talked about, number 1, we talked about the reverse discrimination. And that is an important distinction that we need to look at. We looked at, number 2, the violation of Equal Protection Clause. Why the Supreme Court ruled the way that they did. That is so important. Number 3, unequal opportunity in education. Unequal opportunity in education. Then we see the lack of individual merit. And finally, we talked about the underrepresented. So I pray that these things have helped you better understand why the Supreme Court ruled the way that they did, and not to take it as them being filled with a bunch of racist people, but understanding that we have to protect all mankind and to be impartial when it comes to that. We're not trying to advance equal outcome. We're trying to protect the rights of every human being so they can have equal opportunity to be the best version that God has called them to be. So I pray this has been a blessing to you guys. If you listen to this podcast and you find it to be encouraging and is helping you strengthen your faith, and also to be bold enough as an advocate of God's truth to go out there and engage and have these discussions with people who may not favor your opinion or side with you, let us know by emailing us at info@standstrongministries.org. And wherever you get your podcasts, make sure that you guys leave us a review to help other people just like you learn about this ministry, to teach them how to have challenging conversations. Till next time, keep having those challenging conversations.